Well, welcome back to our channel, everybody. This is Bert here for his second All-Star appearance on the Williams Elleby channel. I'm Joel. And today we actually want to answer a specific question which we very much appreciate from a viewer. H. Chambers asked us, or she says, or he says, "Love your videos, very informative. Can you do a video explaining how having multiple serious injuries from one accident while on workers' compensation works, and how those impairment ratings are combined and calculated? And if you have two injuries to the body as a whole, does it get calculated or the body or the whole body is included? Thanks so much." All right, well, thank you for the question. And because I don't do workers' comp, Bert does, we're going to attack this from a multifaceted approach. I'll throw in some things and talk some discussion about impairment ratings when it comes to third-party injury claims, and we'll let Bert handle the workers' comp specific portion of it. But why don't we get started with the very basic of what is an impairment rating?
Yeah, and that is a great question, very informed actually. So an impairment rating is going to be a percentage given by a medical doctor, hopefully a treating provider, who has explored the injury, knows the symptoms, has seen the affected body part, and then they consult what's called the AMA guides. And workers' comp here in Georgia, the system or the state board requires that it is the 5th edition of the AMA guides. And they basically take the injury, the symptoms. Sometimes they'll get an examination or a functional capacity evaluation to see what they are capable and not capable of doing. And then the doctor just issues a percentage that indicates that that is basically what that body part it has of a permanent injury. So as the question actually indicated, it is usually done in equivalence of a whole body or whole person. And so if you injure, your pinky finger, that's going to have a percentage to just the pinky, then the hand, then the upper extremity, and then the upper body. Whereas if you injure your spine, that's automatically the whole person. And the percentage is basically calculated to say that from here on out, you will no longer be able to use X percentage because of this injury.
Yep, and it's very similar in third-party liability claims where we see, falls or car wrecks and that kind of thing. Really, the benefit in those third-party claims is because we're trying those cases before a jury in the county where we bring the case. So 12 people are brought in that are residents or citizens of that county. And they hear the case. So what we can do is the treating doctor uses a very similar approach to what Bert just described and assigns that impairment rating. And if it says, well, you have a 4% permanent partial impairment rating to your arm, but then you have a 2% to the whole body, then we can look and say, okay, well, this person's 35 years old. They can reasonably be expected to live to be 75 years old. So they now have a 2% disability to their whole body for 40 years. Mm-hmm. And it's permanent. So we then extrapolate damages over the next 40 years using that impairment rating, so it can be very, very helpful to us. And not all cases are appropriate to have a permanent impairment rating where somebody fully recovers, but a lot are, especially surgical type cases where hardware is implanted in the body or there's reduced range of motion or anything like that. So we talked a little bit about how impairment ratings are performed. When are they appropriate for comp cases?
Yeah, and you brought up, just for a brief kind of how it applies to comp, you indicated that the person will live 75 years, so you'll take a 2% for the rest of their life. In comp, you are only entitled to 400 weeks of medical benefits from the date of injury. And so comp has kind of changed the usefulness of the impairment rating to say that it has to be within those 400 weeks. So each body part is actually given a determined rating of weeks that it's affected. So the whole person is 300 weeks, for instance, in the comp setting. And so the percentage that you're given is multiplied by that 300 weeks times your comp benefits, which is 2/3 of your average weekly wage. And so when is it appropriate in a comp setting, or when is it relevant? It would be once a doctor has indicated that you've reached what's called maximum medical improvement, MMI, the doctor will then contemplate the impairment rating. And as I indicated previously, sometimes they want you to undergo what's called a functional capacity evaluation. It's a series of tests that just test your ability to perform certain functions and tasks. And they may base the rating on that, but they will always, or they're always supposed to, consult that AMA Guides 5th edition to give it. And they are not able to give that until you've reached MMI, because the thought is, well, it's too premature. If you aren't at the maximum medical improvement, then you have improvement to go, and an impairment rating would be premature. So you should always wait, or doctors should always wait, or you should wait to ask your provider until they basically release you from care to give you an impairment rating.
Yeah, and one thing I was going to bring up in these third-party claims that Chase and I handle a lot, it's usually the treating doctor that's the one that's doing the evaluation and assigning the impairment rating. Is it similar in comp, or is it someone else that does it?
So ideally, it would be the treating provider. That's going to usually be the person that is examined. The individual has a treatment history, has experience seeing them, and they would probably, in most cases, be best suited to provide that. But there's always exceptions, and clearly, if sometimes there's a disagreement over impairment ratings, that some doctor may have not taken something into consideration, or maybe they didn't even consult the AMA guides. They kind of just said, well, he's got these issues, here's the impairment rating. And so, if that's the case, you might want to take a second look, get a second opinion, talk to your attorney, see if there's anything you can do. But the quick answer is yes, a treating provider would be the best suited in most cases.
So let's imagine a scenario where the treating provider issues an impairment rating, and either the claimant or the other side disagrees with that impairment rating. Can they, is there a procedure where they can have a different one done? And if so, what if the impairment ratings assigned by both of those doctors are different?
Yeah, so every situation is different. Procedurally, if you had been receiving income benefits, and typically how this would happen would be you're unable to return to work because of this injury, and so you have not gone back, or you're going back in a different capacity, but in any of those scenarios, you're receiving some form of income benefits. Well, then a doctor says, yeah, now I think they've reached maximum medical improvement, they're capable of full duty work, but I'm giving them an impairment rating anyway. Well, once your income benefits are suspended or cut off for whatever reason, the other side has a period that they have to request that rating and then pay you out what's called permanent partial benefits, and those are PPD benefits, and they are really why we obtain the impairment rating in comp, because you're going to be paid out based on that rating. And so the scenario that you presented would be that treating provider, called the authorized treating provider, ATP, says you've reached maximum medical improvement, and I think you have a 1%, let's just say whole body rating, a rating for the whole body. And the claimant, the injured worker, is incapable of lifting even 10 pounds at that point, or has consistent back pain that just there's no medical procedure that can improve it. Then there may be questions. You may say, well, 1% seems pretty low. I can tell you right now, if I'm not able to lift over 10 pounds, I would say that should be higher. Yeah. And, they're going to look at the things. They need to consult the AMA guides. And, attorneys, we can feel that they should be higher. The injured party could feel that it should be higher, but really a doctor's going to have to make that determination. And so what you would do is request a second opinion, and in certain situations, the employer and insurer may have to actually foot the bill for that second opinion for an independent medical examination. And as part of that independent medical examination, known as an IME, they should ask, what is an appropriate impairment rating? And once that second doctor gives it, that second doctor has no actual authority under the state board. However, it does have some sort of influential authority, and that combined with the plaintiff's testimony and other information may persuade a judge to say, you know what, I actually do agree with this other doctor. If this person isn't able to lift over 10 pounds, then I do believe it's maybe a bit higher, and I believe with the second opinion. Most of the time, the parties will get together and maybe even negotiate, though, okay, what's the in-between? And generally, that'll happen when they reach a compromise with the whole claim.
Yeah. Well, ultimately, if the goal is to get it right and get a true and accurate depiction of what the actual impairment rating is, sometimes having that second opinion can come in handy, because the reality of the situation is that there are all kinds of doctors that, how do I put this politically correctly? Or do I even need to be politically correct? So I'll just put it this way. Some doctors are really in the pockets of the insurers. Some doctors are in the pockets of the claimants because they get sent a ton of work from both sides, right? What we really need to get it right is an opinion from a doctor who is not biased towards either side and get that neutral opinion. I would envision that 1% example would probably come from a doctor who does tons of work for the workers' comp insurance carriers. You know, somebody that may say, well, you jammed your pinky and you've got a 25% whole body impairment rating. Well, understandably, the comp carrier is going to have some questions about that, right? So the truth is probably somewhere in the middle, and if the parties can recognize that and engage in good faith negotiations, maybe you get the right result. All right, so here's the most interesting part of the question to me, and I'd like to address that now, and it's when you have multiple injured body parts. Say you've got an injury to your arm and an injury to your knee, but it's from the same incident, right? How does that affect the assignment of an impairment rating in the comp context?
Yeah, thanks, because that is a nuanced thing in comp. So you're entitled to the impairment rating for each affected body part, in each injured. So it may be that the doctor looks at your arm and says, well, I think you've got a 5% for the upper extremity, and then looks at your knee or your legs and says, I think you've got a 10% for the lower extremity. But taken together, I think that that's 3% of the whole person. And these are not scientific calculations here. I'm just using as an example purposes. The 5 and 10% are going to be worth more to the claimant in terms of getting PPD benefits. And so the statute provides that they are entitled to the greater of the amount. And so that happens actually frequently. Or, interestingly enough, the doctor could do the same impairment but for different things. So one for the finger, one for the hand, one for the whole person. And even between those three, one of those is higher than the others. Well, in that case too, example, the highest would go to the claimant. That's what they are entitled to in terms of benefits. And so
now, is that this method of calculation, is that something that's Georgia specific, or is that just standard across the nation?
That is Georgia specific,
Okay.
But I think that most jurisdictions have similar patterns, although again, it's great point. Each workers' comp system is controlled by its state. It's administrated by each state, and they're all going to be different.
Yeah.
But in Georgia, that's exactly how it goes.
Gotcha. So take what Bert's saying with a grain of salt. So if you're in Georgia and you have this question, then certainly this is very solid advice. If you're in Nebraska and you have this question, it's probably best to, now you know what it's like in Georgia, but it's always going to be in your best interest to reach out to an experienced workers' comp attorney in Nebraska to get the specific answer there.
Yeah.
But so another question is, when you have, I guess you could have one injured body part, but anytime you have an injury in a comp setting, what if you have some underlying issues like, arthritis, or you've had a prior injury to that body part, things like that? How does that affect the assignment of the impairment rating?
Yeah, and it generally probably does. So does it affect, I guess, would be the initial question, and probably is the answer. And the authorized treating physician, again, is going to be the one to make that determination. So I think it's in the interest, as you indicated earlier, you want to find out what's the right answer. Where are we? And so I think it's in the best interest to eliminating guesswork for both parties to really go back to that authorized treating physician and say, look, I know you've given them a 10% rating for the whole person, but were you aware, doctor, of X, Y, and Z? And generally that's going to be on the employer and insured to ask that question, because they're going to want to reduce that 10% by anything that they can. And the doctor may say, you know what, no, I don't agree. I believe that I've already taken out all these pre-existing. I was aware of those issues. I'm talking solely about this injury, and I sit at 10%. And so I do think, though, with pre-existing injuries, you are going to probably have some percentage that you came into the accident with, that again, the system is only designed to get you back at where you were before the accident happened. And so it is generally fair to take away or to contemplate what percentage of that impairment was pre-existing.
Yeah, it's almost like when you have property damage to, if you get in a wreck and you have property damage to your car, the at-fault party doesn't have to buy you a brand new car or, pay you what you paid for that car. They just have to pay you what the value of that car was at the day that it was wrecked. So that's kind of a more material example as opposed to a body, but I guess the thought process and the rationale behind that is very similar.
Yeah, completely.
Okay. I think we've answered this question. I wanted to add one question to it, and it deals with dollar amounts that are assigned to impairment ratings. In Georgia, is there for a comp case, let's say somebody has a 10% impairment rating assigned to their shoulder. Is there a way that you come up with a specific dollar amount for that impairment rating?
So that's going to be the calculation. It'll be the impairment rating times the affected body part, which has an equivalent time period associated with it. As I indicated, the whole person is 300 weeks, but each body part has something different. And so, a finger would be actually different than the thumb, which would be different from the hand, which would be different from the whole arm. And they are all assigned a different rating, and you would take that amount of time, and it's done in weeks, times the impairment rating, times and when I say time, multiplied by the average weekly wage at 2/3, which is equivalent to the comp rate. So the equation is impairment rating times affected body part times the workers' comp benefit rate, and that gives you your PPD benefits of what the person's entitled to. And it would be an exact sum.
Okay. So the workers' comp benefit rate has a different number assigned to each body part.
Correct.
Okay. So that just goes into the calculation to figure out what the ultimate overall award should be.
Yeah, that's right. And again, if you have a different percentage for the hand, doctor contemplated hand, arm, and whole person, which is common, even though there's one injury, the injured person is entitled to the highest of those amounts. And similarly, if it's multiple body parts, you're entitled to the highest amount when added together as well.
Okay, awesome. Anything else that you think is important to explain regarding impairment ratings with comp claims?
Just know that you're entitled to one, that if you are injured at work, they are entitled to provide you with medical treatment. They are entitled to compensate you for 2/3 of your average weekly wage if you miss time from work. And that once those two things are done, just because you're sent home and said you're good, it doesn't necessarily mean your case is over. You should be entitled to at least ask the doctor if you have a permanent impairment rating, and the employer and insurer are required to provide you compensation for that impairment rating.
Okay, all right, makes sense to me. Well, thank you very much for popping in and sharing some more of your knowledge with us.
Sure.
In the show notes or in the description of the video below, we'll include a video that Bert joined me with earlier this year dealing in more generality with workers' comp claims in the state of Georgia. So if you have more general questions and about the comp claim process, be sure and check out that video. But otherwise, if it's been helpful to you, give us a thumbs up, subscribe to our channel, or give us any comments in the section below. We always try to answer them, just like we try to answer this question today. Hopefully it's been helpful. But otherwise, we will see you next week when attorney Jared Easter with our firm is going to join me and discuss suing the federal government.